Welcome and thank you for joining us today on A Lawyer and a Mediator Walk into a Bar. We'd like to acknowledge the traditional custodians of the land from which we broadcast today and acknowledge their elders, past, present, and emerging. Hi, everybody. This is Paula. This show is not about legal advice. It's really just about our experiences going through the process in the family law courts, what can work, what doesn't work, what's for you to consider to try. And it's just about the process, giving you some familiarity with it, and hope that gives you a little bit of a help.
You're listening to a Mel and Kim Productions podcast. What happens when a lawyer and a family mediator step into a bar? Join us to find out. Dianne and Paula have real conversations about the family law process in Australia. Whether you're a part of the family law system or about to engage in the process, find out what the realities versus perceptions are. Dianne and Paula don't hold back on their individual perspectives and experiences.
Hello everyone, thank you for joining us. My name is Dianne Loveday and my colleague and friend
Paula Applehans.
And welcome to another episode of A Lawyer and a Mediator Walk into a Bar. So today we're going to discuss 60I certificates or S60I certificates or whatever your lawyer calls them.
We call them 60I certificates.
I get some different...
Really?
Yeah, some different things. And I got berated by a lawyer once because I didn't say it the right way. But anyway.
It's your dispute resolution certificate. Resolution.
Well, exactly. It's the certificate we issue if mediation fails for whatever reason. So
for whatever reason, we'll go into those. But that's the whole point. It's either there was a genuine effort, that's the best of all worlds, and you didn't come to a resolution, but both parties appeared, both parties engaged in the process. They made a good faith attempt, effort. So that's the one I like to see.
Do you?
It lets me know the parties gave it a go.
Okay, fair enough.
Well,
and I'm going to say straight off the bat, I hate issuing them because to me it's a complete fail. I feel like
we got definitions again.
Yeah, I hand this thing over to people and it's like, now go swim with the sharks.
Hey, I'm a shark.
Yeah, but you're a nice shark.
No. Yeah. I'm a silky shark.
You are.
That is a very real species in Australia, by the way. Just throwing that out there.
Fair enough.
Yeah,
okay.
I'm good with that.
I brought one along to make sure I got this correct because, again, as I said, I don't like issuing the things that much. So there's actually 5 categories.
You don't like issuing the 60I certificate, period?
Period.
Okay. That's interesting.
I'd much rather produce a successful mediation.
Okay, no.
Yeah,
fair
help
enough.
people reach an agreement. Yeah. I mean, I'm not backward in coming forward when I need to issue one.
No.
And the 2 that I issue the most are refusal to attend, because as much as I, it's a compulsory process and I make every effort to get people to attend, and there is a requirement that I must invite somebody at least twice, make contact twice, in order to get them to attend.
So there's a defined order. It's not like a one-off where you're like,
just in case you might want to come.
Let's just do this. And, there's a real commitment and requirement.
There is a commitment requirement. And as we know, mediation is compulsory or mandatory, I'll use the right word, across all areas of family law.
I've seen the word compulsory in certain articles,
okay. So that one I issue, obviously, when my other party doesn't attend. But I'm also a bit notorious for a non-genuine effort. So if somebody attends and doesn't make a genuine effort...
What does that look like? Give an example. Because...
And I actually think we had this conversation, but I'll go over it again because this one was pretty specific. This is where the party basically sat in mediation. It was a really simple discussion about secondary colleges. Dad was just digging his heels in that it couldn't be a religious school at all. Would not even entertain the idea of going and having a look at a religious school. And Mum was
his line in the sand.
Yeah, offering up all these options, and he just had what it was that he wanted to do, and that was all there was to it. And he just basically didn't engage. And then the cherry on top was when he told me that, and besides, you're a psychologist, and anthropologists hate psychologists, so I really can't agree with you. So
he went to that level.
He went to that level.
So had you been an anthropologist instead of a psychologist?
Oh, yeah, probably. I would have carried a bit more weight. But
Professional snobbery, but okay.
one that's very recent and very relevant that I think that if I had a successful mediation. Yes, what I class as we reached an agreement yesterday.
That is successful, though.
Yeah,
I would agree too.
Except Dad. Oh, well, I shouldn't use gender. One of the parties is incredibly cagey about the outcome. Again, it's about schooling. You'd be surprised how many people cannot agree on where kids will go to school. And incredibly cagey and asking all sorts of strange questions and making all sorts of strange stipulations. And I'm just going with the flow. We've got an agreement. I'm going to type it up for you and send it to you. I'm going to get you to sign it. And he's agreeing to do all of that. But I've just got a feeling, there's an ulterior motive floating around in the background somehow.
Just because of the questions or because
of the way he
feeling?
asked to have it worded.
Oh.
Yeah.
Well, when they do that, are you able to say, yes, that's the intent of the agreement, or no, that's not the intent of the agreement?
I did that, and I shifted the wording to make it a little bit less prescriptive, and tried. My parenting plans are there's no legal speak.
No, I've seen a couple of yours, but they're very straightforward as well. So, I mean, it's not like there's a lot of room for interpretation. It's that's the declarative sentences throughout.
And bad spelling and handwriting.
We won't go into that.
No. My goal with a parenting plan is to help people come to terms with having conversations as co-parents. Yeah. So I don't see being legalistic and using legalese as really conducive to that. So I do try.
Probably counterproductive, because once you start using legal terms, everybody gets a little spooked.
Yeah, exactly.
They just do.
So yeah. So that's my ultimate goal. But anyway, so this guy, this parent, he's just left me a little uneasy. So I'm waiting to see where this goes. I'm happy to believe that he'll do the right thing, and.
Both parties are still they've still agreed on the wording.
Yes, they both agreed on the wording.
Okay.
And they've both agreed to sign that it was a country. So I was on video, so it was a country situation. But so the non-genuine effort. I know I have colleagues who feel that if they both turn up and try, that's a genuine effort. That's a genuine effort.
Whether somebody sits down and just crosses their arms over their chest and doesn't even say a word. Is that even?
Well, that very rarely happens. I don't think I've ever had that. But you get it. You get it when there are people who see us as a soft option and think they're going to manipulate the process.
Ah.
Yeah, to their own ends. There are people who will engage only because they want the certificate.
That's what I see a lot of. And we can go over as we go over each of those sections, because when they come to me, the other side has usually requested the dispute resolution process, because you have to, or I have to remind somebody that we haven't done this yet. And I've had other attorneys say, "Well, don't worry about it. We don't need to worry about that. We've got an answer for that." And I'm like, okay. Well, again, that goes back to the certificate. So once I see that, I get a better idea of what they're coming after, or what they've done.
Well, at least you read it, which is really good.
Well, I like, because so there are some folks that will put additional notes in and not just tick the box on the different aspects of the certificate. So there's at least some sort of guidance, or at least some sort of idea of what was intended or what happened. There's nothing in there that's going to give me the absolute, this was a farce, except it's non-genuine. But there's usually a note that says why it was not genuine. Yeah.
And I think I think that's a really good path. But there's a lot of purists in my profession who would not do that.
Purists? Do they just tick the box? Is that what you mean?
Just tick the box. Okay. Yes, just tick the box and see themselves really. It's not their job to make any further reference. So horses for courses. So we have the refusal to attend, and it's important to note that it's written in the reverse. So it's actually written, and I can actually read it exactly to you. So let's say, Paula did not attend family dispute resolution with me and the other party or parties to the proceedings but that person's failure to do so was due to the refusal of or failure of the other party to attend.
Well, that's verbose.
Isn't it? Isn't it? So
That's very wordy to say the other side didn't show up.
Yeah, and that's basically what they're saying. The other side...
It failed because the other side didn't show up.
But, I get people getting a bit confused and say, oh, no, you've put the wrong name down here. It's not... I say, no, it's written in the reverse, so I do apologise, but I can't change it. It is what it is.
The wording probably could be a little more.
I can issue a certificate because people attended and they did make a genuine effort. And as I said, it's... I'm a bit old school. I think the genuine effort is you reach some sort of agreement.
Well, like I said, if you can even tailor it down a bit to the issues to go forward, that to me is a success as well.
Yeah, fair enough.
Maybe not your definition of success, but for me, anytime you can whittle down
the issues,
what's actually in contention, I find that successful because that to me is a good start.
Yeah, no, that's...
So tag team.
Yeah, no, that's good. The other two, because the other two really relevant ones are that if the mediator feels it's not suitable, and a lot of people don't get that it's actually our job to determine whether mediation is.
Well, let's talk about that for a second. How do you come to that? I mean, I know you have to do the
pre-mediation intake interview.
Yeah, the intake interview. And is that where a lot of those things occur, where you're like, okay, the parties just are too far apart, they're just too... I mean, what give us some ideas of what that actually...
It's generally to do around the family violence issue. And, I know that's a whole other topic, and we'll touch on that later and do a full session, probably two, on that one. But for the issuing of the certificate, so, a client comes and sits with you and you have this intake interview. Now, I run... at least an hour, if not 2 hours, for an intake interview. So
nice. Okay, so you're really sussing out.
Yeah.
The people, the issues. It's not. So this isn't just a tick box kind of okay. Are you going to? What's your name? What do you want? It's a real in depth
completely
for that kind of time frame.
Yeah, you've got to look. Well, one, you're managing expectations.
That's a large part of it, isn't it?
Big part of it. You're also managing for issues. So what do you have to... Remembering I'm bringing people together into a room on my own with nobody else there.
No security, no bouncer, no...
None of that. So it's all about...
Not even a dog.
Not even a dog. So what am I managing for? What are the triggers? What are the issues that I have to be mindful of when I bring these two people together? And should I bring them together? Because there's variations around what... the levels of family violence. So if both parties want to attend and I deem it appropriate, but I might need to put somebody in a separate room. Or have
the mediation could still occur.
Yes.
But you've already sussed out between the parties. Mm-hmm. Is there going to be some conflict?
Yeah.
And can we manage this conflict?
It's not
a conflict, or
it's more about how comfortable people are sitting in the same room.
Okay.
So if you've had, a financially controlling party for a long time, sitting in a financial mediation and negotiating for yourself is very daunting. Right. So it might not be appropriate. So we'll pop them in a separate room. That would be the first step.
Right. Okay, but you would still work to manage an actual...
Oh, absolutely. Yeah, that's very much about hearing their story, because that's the other big part of an intake interview, because we get two stories. We hear both sides.
Sometimes you get 3 or 4. Depending on how many personalities are involved.
Well, that's true. But for the most part, I get to hear both parties. Yeah. So I'm managing that. So I need to be very mindful. Mm-hmm. I have a new FDR working with us at the moment, and she's falling into the trap of believing every single...
Oh.
Yes, God bless her.
There's that whole aspect of trust but verify.
Yeah.
But at the same time, you can't get pulled into that cyclone.
No.
That's
their storm, their dysfunction. You step out of it, and you've got to be at that arm's length in order to be useful. Because at the moment you get down and dirty, you're not useful.
Well, once you mesh yourself into the situation and you start picking some biases out, or you decide to just take sides.
Yeah, and that's not our role.
And now that's something that you guys have to be very aware of in your own internal
absolutely
review of things.
Yeah, we're
so that's
not
a constant.
To take sides. Yeah, that's your job. Lawyers take sides. We don't. So, yeah, it's a really important point.
But that's something that you have to manage as well.
Yeah,
You know,
yeah.
and-
So
and-
there's a lot of things in that intake interview that and it's a 4 or 5 page document that we fill in.
Mm-hmm.
And in there is also, look, there's a bit of discussion on a group I'm with at the moment about using the DAWS family violence paperwork.
Mm-hmm.
And there's a bit of a consensus that it can be quite confronting for somebody who's in a family violence situation to then be asked in-depth questions about that family violence.
And a lot of that comes back to the denial they've been living in
Yep.
many ways. And all of a sudden here it is on paper
Yep.
in direct questions.
Yep.
And they just shut down.
Yeah, exactly.
And at that point, they're not engaging, and it's to their detriment.
Yeah.
And then what do you do?
Yeah, well, I don't use that document.
Okay. There we go.
So I formulated just a few short questions and a bit of a sliding scale on the level of conflict within the relationship. But a big part of whether I even utilise that section of the intake form is my conversation with the party. You can often pick up whether somebody is in an abusive relationship by their demeanour, by their ability to answer certain questions. One of my favourites is if they'll know contact details off by heart because they have to report in regularly.
Oh.
No,
Okay,
So
so-
they'll know phone numbers off. Who knows a phone number off by heart anymore?
Nobody. I used to be, when I was a teenager, I was a master at it.
Yeah, not
because
anymore.
it was the family home, right?
Yeah.
And I could rattle off, 30 friends' phone numbers in a minute.
Not anymore. So when
Now I'm just, where's my phone?
Yeah, so you can see that's a little red flag for me. If people can rattle off information that most people would have to check for, okay, let me just take this a little further and have a bit more of a conversation around this. And
Okay,
just
so,
see.
so you've tailored some questions in order to suss that out
Yep.
versus the 4 to 5 page
Yeah.
document. That's probably based on your level of experience in the game and just the, again,
and
having
my
your
background degree, yeah,
Yeah.
exactly. That does help, absolutely. But of course, then, even if I think it might not be suitable, it's ultimately the client's decision.
Okay, so a client could walk in there or they call in for the intake, and they come off as just belligerent. He's not doing what I tell him to do. I told him to do this, he's not doing it. So he's, and at that point, do you just realize that they're going to be knocking heads just for the purposes of knocking heads? I mean, I've had a couple that come to me, and literally, they've gone to the family dispute resolution process, and the party that comes to me, all they did was sit there. All they did was just say no to everything.
Well, then that's a non-genuine effort.
Okay,
In my
there we
book.
go.
In my book, yeah. But I've got to get to that point before I know. And I will make sure that party understands this is the certificate I will issue. And are you aware that that certificate then means that there could be a cost order made
Now,
in the other party's favour?
how many FDRS, how many family dispute resolution processes can somebody go to? I know that they're required the one prior to filing. What if they didn't like your certificate? What if they just go, they decide they're going to go to another person?
And
then they go
that.
to another person.
They can do that.
And then they get to figure out which one they're actually going to file.
Well, and then...
Does that happen? I mean, I don't know. I've had one where they've had 3.
Oh, it's called mediator shopping.
Yeah, we call it forum shopping.
Yeah.
Where are you going to get your best answer?
Exactly. You're looking for somebody who'll agree with you, basically, and
Yeah.
produce a certificate or whatever that suits your purpose.
Right.
Then again, it comes back to the mediator, being aware that this is happening, again, by your questioning, understanding what's going on. Sometimes you don't find out until you've spoken to the other party.
Oh, that's, yeah.
This is the 3rd time they've done this. They keep dragging me through this. So, okay, no worries. Now I've got a heads up. Now I understand. It does, that to me, again, is a non-genuine effort. If you're shopping around, you're not making a genuine effort because you're not prepared to listen to somebody else's perspective. You're not prepared to actually have a genuine conversation around the presenting issues.
Well, what's the one there that talks about how both parties came in?
2 is, did not attend family dispute resolution with the other party or parties in the proceedings. I consider having regard to the matters mentioned in Regulation 25 two, family violence, that it would not be appropriate to conduct the proposed family dispute resolution. So I have that discretion to, and now I think.
So how about that one? What are some of the things you see as to why you would tick that one, or do you even use that one?
I don't use that.
Okay, there we go. You're going to define it more in one of those others.
There are mediators and there's mediators. Let's be,
Just like there are lawyers and lawyers.
Yes, exactly. And there are, and I had this conversation with a young lady exactly this morning about the philosophical differences. So if you are a facilitative mediator, you see your primary role is to just stop them killing each other.
Wow. Have you had those type of mediations in your experience?
No.
Have you had anybody actually, blow up, perpetuate some violence while you're in the mediation?
I've had them storm out. Yes.
Okay, storming out is fine because they're taking it with them.
Yeah. But
I'm okay,
we were mid-sentence. I needed you. Yeah. We were nearly there. I had somebody, very end of the process, and it was really difficult for this person because we were asking them to sign a document they really were not comfortable signing, but they had entered into a 3-hour negotiation and they'd received a lot of concessions, but this one concession that they felt wasn't in their best interest I watched the hand start to shake. Then they stood up, tore it up, stood at the end of the table, berated me and the other party and then left.
Okay.
Doesn't happen often.
Okay. You haven't had a situation where you've actually had to call the police? Or
No.
You just ask the parties to leave and say we're done?
Yeah, I've stood between. I've separated people by taking people out of the room. And it's often because they're so entrenched in an argument.
Yeah.
They can't hear me.
Or an emotion.
Yeah. Absolutely. Okay. And they just start bellowing at each other.
Yeah, and then nothing happens after that anyway.
Yeah, so separate them out and just try and calm the situation down and resume if you can. Mm-hmm. But if you can't, then you issue the certificate, offer them the certificate, and they can move on. But
well, the certificate was designed. There was a purpose, for the family dispute resolution process, and the idea was for everybody to get a genuine effort in before just plunking down the applications. In a proceeding or initiating application, and then get all that started. It was really to get people to say, okay, let's stop for a second. Let's put on our big boy, big girl pants. Let's take a second and be adults. Let's do some adulting and try to come to some real agreements. So there was a genuine, real purpose to it. I think in my world, I've looked back at it, and sometimes, I'm not going to say all the time, there have been times it's actually really worked.
Yeah.
And that's the great part. But when it doesn't work, it actually becomes this additional contention. And we have to file an additional genuine step certificate to the court that says, here's the 60I certificate. It says no genuine attempt was made. And then we're asked additional questions, from our client to submit to the court. Why do you feel, in some ways, why was this not a genuine effort? Things like that. So then we have to clarify to the court, well, we got this certificate, but we still don't feel it was a genuine attempt. And it gets kind of glossed over sometimes as to, well, then you have to do your balancing. Yeah. I could go back in and argue that this was not a good faith attempt. They did all these things. They didn't do these things. We shouldn't be here at the proceeding. But really all that happens is it'll get kicked out. It'll get kicked back to go back to a dispute resolution.
Yeah, so
where all they got to do is call and do during the intake saying, well, we tried it before and it didn't work. And how much, so you really just re-exercise
the whole purpose of...
Yeah.
Yeah, okay. So,
And there are costs that could happen, for going forward. But then you still extend the time to resolve, to get back into court. So at one point, and this happened to me in the last 6 months, where they had one certificate, we had one certificate. One said that the parties were not good to mediate. The other one said the other side failed to appear. And so we had two competing certificates. And we're like, well, we could argue that they didn't follow the process, but all that would do is kick it back out. It would extend the time. They'd have to refile. We get our costs, but the matter doesn't get moving.
There's a flaw.
Yeah, so it's like
a problem.
So do we want to kick this out? Do we want to? It's just procedural.
Yeah.
But I guess that's a bit of an incentive on the other side to not screw up, so that way we can say, oh, well, we'll get costs, but it's just procedural. It doesn't resolve anything. It delays the process that it's eventually going to go back to as far as litigation.
But where are the consequences for the people not doing the right thing? That's my frustration. I mean,
Well, that's the frustration. So we have consequences at the court level.
Yeah, but
We do have consequences.
But in the meantime,
But they're almost meaningless.
Yes.
If you ask me, because it's just extending what's going to happen already. And if it's about spending time with the child, all you've done is put it back into the blender.
Yeah.
And
Yeah.
yeah.
Okay.
So
Yeah.
did you have any other points you wanted to make
All right,
about?
I was trying to, what else have I got on here? Began attending family dispute resolution the other parties to the proceedings and I consider having grudge and match mentioned it would not be appropriate. So basically the last couple of to do with family violence or issues.
Well, and that's one of the really, and I guess real quick, that is a primary reason to not be able to go to a family dispute resolution process. And it is something that you do suss out at the intake level. So I want people to understand that, yes, there is it's got to be if there's an urgent application, then, but again, you have to particularize, you have to say exactly why it's an urgent situation. Yeah. So there are mechanisms that say you don't need this certificate, but they're very few. They have to be particularized, they have to be articulated, they have to be precise. Family violence absolutely is one of those. Yeah. It's easier if it's part of the intake process to get that certificate that says, hey, there's family violence. But at the same time, you can still bypass the family dispute process. And again, family violence is what it is, and it can be as subtle as it's very subtle, very, very snaky, very sleek, very under the radar kind of stuff, or it's very out there. Yeah. So, I mean, but again, as long as you're saying why and your lawyer can be very precise and particularize that. So, I mean, there are ways that if it's an urgent matter, if there's family violence involved, there are reasons that you don't require the certificate to go forward. We were just trying to let people know that there's some good reasons to do it. Yeah. But every once in a while, there's going to be those reasons where you can bypass it.
If needs be. Yeah,
exactly. If need be.
And look, the other thing is the timeframes around it, because a certificate, it has a 12-month life.
That was the other point to make, yes.
Yeah, so it has a 12-month life from the date of the last mediation.
Well, the date of your certificate,
date of the issuing of the certificate.
Yeah.
You have 12 months to request one from the date of the last mediation.
So you have some time to figure things out, maybe think about things again. You can always go back to dispute resolution, so you're not preempted from ever going back. So things change, process changes, or life changes as it does. Yep. It may be something a little more realistic to try again. Yeah. After a couple of months.
Once they find out exactly what the costs are involved of taking it further.
Sometimes that helps. You give somebody a cost agreement on these things, and the eyes bulge out, and rightly so. Yeah. That's why I was like, maybe you want to go back, give it another effort. Give it another good try.
Get in there and have a go. No, absolutely. Yeah, so, look, basically, it was the 60I certificate was explained to me in my training as it's basically the gateway to litigation.
And it is. But if there are circumstances that are a little... not little, but usually they're pretty good circumstances.
And then that comes into the discussion with the level, the number of people and the level of family violence and who it actually ends up it's only about 11% of people end up in a final hearing, and they're the worst of the worst, generally speaking.
They are. Yeah. There's no doubt about it. Yeah. And not just worst of the worst, it's the emotions. Everything gets so wrapped up, it's a little hard to peel back and say, okay, these are the actual issues. Because it's always that he said, she said, and he said, she said, she said. Yeah. They all go back to, I've got one long-term marriage. Back to 2005, he did this. I was like, wow. That's, but to them, it's a very emotional, gripping thing that started everything. Yes. And it's like, well, we're going to have to work you off of that one a little bit. There's some, those kind of things. So, thank you all for joining us today.
Yes, thank you. And I hope you found that informative and have a bit of
Enlightening.
bit
And then just a
understanding.
little more about the process of how this works together.
Yeah,
And when it doesn't, it doesn't. But for the most part, it does.
Yep.
There we go.
And that's what we're here for, to help. So thank you for listening, and
We'll see you back at the next session.
we will.